courtroom to follow the proceedings in English. Every day, the hearings will start at 10 a.m. and conclude at 5 p.m. At 12 o'clock to 1 o'clock there is a lunch break, and from 3 p.m. to 3:30 is a short afternoon break. These times may differ depending on how the hearing goes on any particular day. If the hearing is adjourned, it will always be said at what time the hearing will reconvene. If the hearing is interrupted, the live stream will be stopped immediately. The video projections in the other courtrooms and in the press centre and on the venue outside of this courtroom will be stopped as and when everybody has left the courtroom. As I pointed out, interest in this case is huge. The size of this courtroom, as you can see, is not large, and so only a restricted number of people can take place here in the courtroom. That is why we shall decide in advance who may be present in this or in one of the other courtrooms on any particular day. Information over the possibility on one or more of the hearing days to attend here in the judicial complex in Schiphol can be found at that website I mentioned earlier called MH17.com. Everyone present in this courtroom should be aware that video recordings are being made. Relations and the accused will not be shown on screen if they don't want to, but the judges, the prosecutor, counsel and officers of the court will indeed be filmed. So it is possible that other people present here in the courtroom may appear on screen because they may be sitting close to someone who's being filmed. I'd like you to be aware of this. Let me now say who is sitting here on the bench. My name is Steenhuis. I am a judge at the District Court of The Hague, and I'm the presiding judge in these criminal proceedings. Next to me sit Mr. Koster and Ms. Kerstens Fokkens. They're also judges of the Hague District Court. The three of us constitute the bench in this criminal case. We are the judges who will hear this case, and we are also the judges who will take decisions in this case. Now, because these criminal proceedings may last a considerable time, 2 further judges have been appointed as replacements should that be necessary. In order to facilitate this, these judges will be present throughout the entire criminal proceedings. That's Mr. Glass and Ms. Popper-Gielissen. They are also judges at the Hague District Court. These judges will be present during the hearings, but will not speak unless they are replacing one of the judges. When the bench has to take a decision or deliberate during the case, the alternate judges will not participate in these deliberations. The bench is supported by court clerks, always 2 of those at every hearing day. They are to my left. Their task is to draw up a record of what takes place during the court hearings. In such fashion, we can check how the hearings proceeded and whether all formalities were indeed complied with. On behalf of the Public Prosecution Service, public prosecutors are also present, and counsel for the accused Pulatov and for next of kin. For Mr. Pulatov, counsel is Mr. BCW van Eyck and A.S. Dandushat. Furthermore, Ms. Kutina is present. She is a lawyer in Russia and was approached by Mr. Pulatov to assist him. but she is not authorized to appear as counsel in these proceedings, although she is part of the defense team. There is an interpreter as well here specifically for her, so she can follow the proceedings. I should also like to point out that counsel on behalf of the next of kin may make up the MH17 legal assistance team. So there are 9 counsel part of that, and they are all present here today and represent at this juncture the interest of 398 relatives, next of kin, and 244 victims. Prosecution, counsel for the defendant and next of kin will all be allowed to address the court. I shall shortly explain how criminal proceedings work in the Netherlands. Now, at this particular moment, it is important to point out that the course of a trial is precisely laid down by law, and that means that the treatment of these criminal proceedings follow specific rules. Last year, in June 2019, the court decided on the request of the Public Prosecution Service that the trial will start on 9 March 2020. Then courtrooms were reserved over a number of hearing blocks that start on 8 June 2020, 31 August 2020 and 1 February 2021. There are 4 accused against which the Public Prosecution Service has laid charges. Given that it will only become clear on the day the trial starts, today in other words, of whether one or more of the accused will appear with or without counsel, the court has determined that this, the first hearing day, will be devoted to stock-taking. What does that mean? That means that the first phase of this trial is intended to map out the current state of play. Who will appear at the beginning of these hearings? Is there counsel for the defense, for any of the defendants? Are there counsel for the next of kin? What is the state of play in the criminal investigation? Is the case ready to be dealt with on the merits, or is further investigation necessary? So these are the questions that today are on the agenda. When the Public Prosecution Service made known the decision to prosecute on 19 June 2019 and the start of this trial was made known, it was not clear at that juncture when the complete case file would be available. The case file, right now, is made up of 36,000 pages and an enormous amount of multimedia files. It's a digital case file, and for these reasons you will see us regularly consult the screens. Also, until recently, it was not known whether one or more of the defendants would attend the trial or be represented by counsel. In January 2020, 2 lawyers came forward on behalf of the accused Pulatov, and they've had the case file now for a few weeks. That really means that they've had but a brief space of time to prepare for this hearing. In a major case, it is not unusual that defense, prosecution and the bench consult prior to the hearings, and that has been the case in this criminal case. Prior to this hearing, the bench communicated in writing with the Public Prosecution Service and counsel representing the defendant Pulatov regarding the possible structure of the first hearing days. Counsel and prosecution made their positions known to the court. And on that basis, the presiding judge has decided to give a few pointers, which essentially specifically relate to topics that may be addressed during this phase of court proceedings. I shall shortly go into the position of the different parties to the proceedings in a criminal case, how a criminal case is heard here in the Netherlands and what that means for MH17 and this case. It relates to information that is important for each and everyone, but above all for interested parties from abroad and for foreign media. Next, as the law prescribes, we will proceed to a formal inventory of who has appeared and whether the defendants have been correctly called for today's hearings. Subsequently, the bench will need to take some decisions. Then the prosecution will have the opportunity to address the court. The consideration of the merits in this case will require discussion of the results of the criminal investigation subsequent to the downing of MH17. The fact that 6 years have gone by since 17 July 2014 means that for the next of kin and for other people a great deal of patience has been required. The criminal investigation has led to an extensive case file. And during this trial, the results of this investigation will be dealt with. That means that the substantive treatment of the case will take all the time necessary to deal with it. And I'm quite sure that, especially for next of kin, this will be a very painful and emotional period. There are many victims, and of course, because of that, there are many next of kin. Next of kin have the right to address the court about the impact of the loss of their loved ones. So, at one moment during the treatment of this case, they will be given the opportunity to take the floor here in the courtroom. I'll revisit this point when explaining the course of the trial. This means also that next of kin, exercising their right to address the court, will perforce take time. And that time will be given. That's why we reserved a number of multi-week blocks both this year and at the beginning of next year to try the case. It's not been excluded that more time may be necessary for the treatment, but we shall see this as the trial progresses. Precisely how this trial will progress is something we can't answer right now. I mentioned a little earlier that I would go somewhat deeper into the position of defendants, victims of next of kin in Dutch criminal proceedings. Now, when someone is suspected of having committed a criminal offence, then to justify suspicion there needs to be guiding facts and circumstances which point to guilt in the commission of a criminal offence. And when there appear to be such guiding facts and circumstances, then it is possible within the Dutch Code of Criminal Procedure to open criminal prosecution. Investigation then starts under the lead of a public prosecutor. On the basis of the results of that investigation, prosecution can then decide to bring a case to court and to prosecute a suspect. The grounds for suspicion is then set out in an indictment by the public prosecutor, and then the accused is summoned to appear in
Bij de
court.
beoordeling van de zaak.
When assessing the case and dealing with the case file, the court is obliged to stick to those offences included in the indictment. The bench will only rule on these offences and these offences alone.
Een verdachte komen gedurende
During the investigation and the subsequent trial, the defendant enjoys certain rights regarding criminal proceedings. So, of course, there has to be due process, a fair trial. That means that the case should be dealt with fairly and transparently and within a reasonable period and in independent and impartial fashion. It goes without saying that if defendant is innocent until proven guilty by law. A defendant must also be informed of the nature and details of the charges against him. He also has the right to the necessary time and facilities to prepare himself and to be assisted by counsel and, when necessary, by an interpreter. In this case, we have 4 defendants. None of them have Dutch nationality. Over and above, the offences with which they are charged took place outside of the Netherlands. These criminal proceedings are taking place in the Netherlands so that Dutch criminal proceedings law is applicable. That's law according to Dutch criminal procedure. It means, as provided by law, that the suspects in the case will be assisted by Dutch lawyers. The defendant himself is free to decide whether he wishes to be assisted or represented by counsel. Also, in a case where a defendant does not appear and does not let himself be represented by counsel, it's up to the court to decide or to make sure that due process is followed. In this particular case, counsel has appeared for the defendant Pulatov, and as I said, the right for support and assistance through a Dutch counsel is one of the rights of the accused. It is important that counsel can shed light on the defendant's standpoint. Let me now say a few words about the position of victims and next of kin in criminal proceedings here in the Netherlands. Those who directly suffer prejudice subsequent to a criminal offence are designated as victims. A victim has, under criminal procedure, certain rights which are included in the Dutch Code of Criminal Procedure. A victim can be supported by organisations that assist victims. A victim may also be assisted by counsel. A lawyer or someone else who has written authorisation may represent the victims during the hearings. The victim also has the right to information about the progress of the criminal investigation and the beginning and the course of the criminal proceedings. The victim can also petition to have sight of court documentation that they consider important. A victim may also add procedural documents to the case file. And if a victim has died or deceased because of a criminal offence, he can be represented by somebody else. In this particular case, it's about the suspicion that the downing of flight MH17 and the death of all its occupants is the result of a criminal offence. This means that the next of kin of these 298 deceased enjoy legal rights given to victims. Today,
aantal van de nabestaanden
and a considerable number
vertegenwoordigd
of
door de
next of
Raad van
kin
Coöperatie.
by counsel.
Nabestaanden, andere
Over and
personen
above
die
suffered
zich
prejudice
als slachtoffer melden.
on account of the downing of flight MH17 may register, for
of
example, who suffered prejudice on account of the plane being downed.
Bij de behandeling van de strafzaak zullen de nabestaanden die dat willen
During this
de
case,
gelegenheid krijgen
the next of kin who so wish will have the opportunity to address the court in their own words and to speak about the personal consequences of the death of their loved ones. And also, they may address the sentence that they feel should be imposed in the case of a conviction.
Zo'n verklaring kan ook
Such
voorafgaand aan de
statement
zitting
may
worden
be
opgenomen
recorded beforehand
wanneer deze opname
and played
tijdens de zitting
later
wordt afgesproken.
in court.
Naast de
And
mogelijkheid
over and
om ter
above the
zitting
possibility to address the court, it's also possible to submit a written declaration about the consequences. Submit that to the court. This declaration then will be included in the case file and discussed during hearings, or can be read out by next of kin or a representative of next of kin. Next of kin can, just as victims, file a claim for compensation for prejudice they suffered as a direct consequence of the offences. And in future planning of these hearings, the court will reflect. This will be done precisely, it depends on the number of next of kin who wish to exercise their right to address the court. Right now, we have some idea about how this will proceed. According to the information that the court has received from the prosecution, right now, 49 next of kin have said that they wish to make use of the right to address the court. 82 next of kin wish to submit a written declaration, and 84 next of kin wish to submit a claim for compensation. Of course, these numbers are provisional. The right to address the court will follow the substantive consideration of the case file. So that means that next of kin will be given the opportunity to submit a declaration later on in the hearings. At this moment, the court will make specific arrangements for this in consultations with relatives' counsel. Next of kin and victims will be able, as I said, to submit a claim for compensation and explain this claim.
I've just been informed that there seem to be technical problems. We'll solve the problem, which means that we will interrupt the hearing in any case for 30 minutes.